For those of you I haven't yet met, my name is Elena Maisel, and I'm a co-chair of the conference. I want to reiterate how glad we all are to see so many people here at this event, and particularly, for me at least, at this session on religious liberty and the challenges that it now faces in America. Freedom of religion in America, our first freedom, has enabled religious minorities to thrive for centuries. As Jews, we haven't always lived without social anti-Semitism, but at the level of the state, the government has generally protected freedom of conscience and helped to realize the promise of peaceful coexistence to which the founders aspired. Today, however, Jews, Christians, and other faith communities face a shared threat: a vocal and powerful progressive culture that seeks to impose its values on traditionalist minorities through legislation and through the courts. Recent cases include attempts to force Catholic institutions to participate in acts that they believe to be immoral, including the provision of abortions and the direct subsidy of abortifacients. Jewish shop owners have been sued for requiring modest dress codes. Animal rights groups have sued to prevent the practice of kaparot. Townships have repeatedly attempted to zone out houses of worship or eruvim. We aren't Europe, where kosher slaughter and circumcision have also come under serious attack, but after a drastic change in American culture, law, and politics, that may one day too come to fruition. To help us understand these developments, as well as their implications for American Jews, we have with us two of the best men, the best experts to speak to this issue, Mr. Leonard Leo and Dr. Yuval Levin. Mr. Leo is the executive vice president of the Federalist Society, an organization of around 65,000 individuals advancing limited constitutional government. Most recently, he has advised President Trump on judicial selection, helped to manage the Gorsuch selection and confirmation process, and served as a member of the transition team. He organized outside coalition efforts in support of the Roberts and Alito U.S. Supreme Court confirmations. He was appointed by President George W. Bush to 3 terms to the U.S. Commission on International Religious Freedom as chairman. He was the recipient of the 2009 Bradley Prize, along with the other founders and directors of the Federalist Society, for his work in advancing freedom and the rule of law. Dr. Levin is a vice president of the Ethics and Public Policy Center in Washington, D.C., as well as EPPC's Hertog Fellow. He's the editor of National Affairs magazine, a serious and significant journal of public policy with impact reaching beyond the brands of conservative thought that it represents. He's a contributing editor of National Review and the Weekly Standard, a senior editor of EPPC's journal, The New Atlantis, and most recently, the author of The Fractured Republic, Renewing America's Social Contract in the Age of Individualism. He is also a recipient of the 2013 Bradley Prize for Intellectual Achievement. Dr. Levin will speak first, providing a deep historical and cultural understanding of religious freedom in America and how that understanding shapes modern debates. Mr. Leo will explain the state of concrete legal and policy battles, both at the state and federal level, and the significance of judicial appointments over the next few years in shaping religious liberty law. Thank you.
Thank you very much. Elena, thank you for the introduction, and really thank you very much to Tikva for organizing this extraordinary gathering. I think I've had the feeling that a lot of people have, just looking around and thinking, there's more of us than I thought. That's good to see. I'm also particularly grateful to be here alongside Leonard Leo. Leonard is really the only person in Washington who's doing his job properly now. And his job really couldn't be more important. He's spent decades building the infrastructure for defending our fundamental rights, for one thing, and for reinforcing our system of government. And in the past year, really, whatever you might think in general terms about how things are going under the Trump administration, you'd have to say that the appointment of judges has been going very well. And Leonard, really, more than any single person, maybe except the president, so I'm very grateful just to sit next to him and hear what he has to say. We're here in this session to talk about religious liberty, its relation to American Judaism and to conservatism. And for me, the general subject always brings up a story, a story from my own experience. In 2006, 11 years ago, Good Friday ended up, by coincidence, falling on the same day as Purim. Good Friday is the day in which Christians mark the crucifixion of Jesus. The Jews, of course, historically have often been blamed for it, and Good Friday was the date when many of the worst pogroms in European history happened. It was a date when my ancestors and yours, many of yours in Europe, spent cowering from their neighbors and in fear of their lives. On Purim, of course, we celebrate a kind of moment of Jewish survival in the face of such threats, and these 2 days fell on the same date. I was working in the Bush White House then. I was a domestic policy staffer working for George W. Bush, and a group of us White House Jews got together with the rabbi of one of us, my boss at the time, Tevi Troy, who came in to read the Megillah with us, to read the Scroll of Esther with whoever wanted to. And one of us White House Jews, was the person who was called the president's body man, the young man who just walked around with President Bush all day, carrying his wallet, carrying his comb. He spent every minute of every day with him. And he asked that day for an hour off in the middle of the day to go and read the Megillah with this rabbi. And the president asked him why. And so he told him what we were doing. And President Bush suggested that we do this rather than in the office of one of us in the old executive office building, that we do this in the green room of the White House. The green room used to be President Thomas Jefferson's office when he was president, and the furniture in the green room is original. Some of it is. The chairs are original. They were there when Jefferson was there. And it occurred to us sitting there that here we were, Jews in America, literally being permitted to sit on Thomas Jefferson's furniture and read the Hebrew Bible with a rabbi. This is how America treats its Jews. It was a moment of just immense gratitude for this country. And for me, when I think about religious liberty, it is that sense of gratitude and the recollection of that moment that so often comes back. And so it's a little strange to get at the question of religious liberty in the way in which we should and will this afternoon, which is with some sense of concern. It's a little strange because we as Jews should certainly approach that question first and foremost with a sense of gratitude for this country and for the freedom it affords us, including, of course, the religious liberty it affords us. The significance of the question, of the subject of religious liberty, could hardly be more obvious. Jews are a religious minority in this country. We depend upon the protection of religious liberty to be able to practice our religion, to be able to participate fully in our society. But of course, that necessarily puts things too simply, too broadly. And put that way, it might be hard to see, as I say, why we should be concerned about religious liberty. On its face, the freedom of American Jews to believe what we believe and to live our lives accordingly is not in any obvious way under extreme threat at the moment, and we should be grateful for that. But we should be concerned, too, because there's more to religious liberty in America than that, and because there are currents in our culture and politics that have been threatening the religious liberty of some of our fellow citizens, and that should be of grave concern to us, both because we should always be concerned about threats to our fellow citizens and because they raise the prospect of serious threats to the religious liberty of American Jews as well. The prominence of the principle of religious liberty is obvious in our constitutional tradition. The very first words of the First Amendment say, Congress shall make no law respecting an establishment of religion or prohibiting the free exercise thereof. Religious freedom is the first freedom in the First Amendment to the Constitution. But in that very articulation of that first freedom, we find a hint of the complexity of this particular right in our legal and constitutional tradition. And what I want to do briefly in these remarks is to follow up on that hint just a little bit, to trace some of its implications, to think about that complexity, and to see some things that maybe we as Jews in America should particularly make sure that we notice. Our first instinct when we think about religious liberty is to think about the second clause of that provision of the First Amendment, to think about the free exercise of religion. That would seem to be where the relevant protections lie, in the protections of our exercise of our religion. And it would also seem to be the most relevant kind of protection to a religious minority that wants to carve out some space for its distinct way of life. Free exercise jurisprudence is often involved crafting prudential exemptions and accommodations, exactly carving out spaces that could allow religious believers to act on their convictions even in the face of contrary public sentiments, up to a point even in the face of contrary public law. When a law or a policy seems to put our religious freedom in jeopardy, we can protest in the courts that is a violation of our free exercise of our religion. But the logic of free exercise, at the same time, is a very highly individualistic logic, and we should notice that and think about what it means, because the problems that religious people confront now are frequently communal, or in the deepest sense, corporate problems. The free exercise clause offers a defense of religious freedom that's rooted in a defense of individual conscience, and in turn, in the broader classical liberal logic of individual rights. And these are enormously important principles, and they offer enormously important protections, but we should understand their limitations, too. The English tradition of religious toleration, which is the source of our legal ideal of free exercise, arose in the wake of bloody religious wars in Britain, and arose to enable some peace among conflicting sects by keeping individuals' beliefs out of the reach of the state. This was done, remember, in a nation with a strong established church, so that the freedom that was enabled by religious toleration at its origins was a freedom of private worship and belief for dissenters and minorities, but not quite a freedom of common action in the public square. Religious freedom was, in this sense, a very liberal kind of liberty, a freedom afforded to individuals to keep them out of each other's hair, and so to keep the commons peaceful and orderly despite their differences. The circumstances of early Enlightenment Britain also meant that this toleration itself was selective from the outset. It was intended to protect Protestant dissenters, but to offer less protection to Catholics. And this aim meant that toleration quickly took on a particular form that has some troubling implications for our own situation. Even the greatest statement of the early Enlightenment toleration tradition, John Locke's Letter Concerning Toleration, which Locke published in 1689, shows us this troubling form, this problem. Locke argues that there's no reason to ban the belief or the profession of any article of faith, since beliefs don't do any harm. He wrote, quote, "If a Roman Catholic believes that to be really the body of Christ, which another man calls bread, he does no injury thereby to his neighbor. If a Jew does not believe the New Testament to be the Word of God, he does not thereby alter anything in other men's civil rights." End quote. Individuals, in other words, can just believe whatever they wish. But institutions formed around beliefs were not to be tolerated in quite the same way if they were supposed to exist for a purpose beyond just the expression of faith. And this was especially a problem for Catholicism, which is a uniquely institutional form of Christianity. And Locke intended it to be a problem. Catholic beliefs could be tolerated, but the institutional existence of the church, the hierarchy that answered to a pope that Locke repeatedly calls a foreign prince, could not be tolerated in quite the same way. The Act of Toleration, which Parliament enacted in 1689, very much following on Locke's logic, set out the same kind of distinction, and it remained a part of English law, the English tradition of religious toleration, until well after American independence. So that tradition of toleration established a highly individualistic understanding of the right of conscience and of the protection of religious practice. In this sense, the particular question that's been at the heart of a lot of our religious liberty cases in the past few years, the question of whether institutions in the corporate form are entitled to religious liberty, is not a new question for our political tradition. And the answer that tradition has often offered to it is not simply friendly to the situation of contemporary religious people, Christian and Jewish. In 2012, when the Obama administration first proposed what came to be called the HHS mandate, requiring employers to provide insurance coverage that included free access to contraceptive and abortive drugs, it provided a very narrow religious exemption from that rule that really, I think unintentionally, but very closely echoed the kinds of distinctions that were first made in those earliest forms of the English tradition of religious toleration. And an organization could only count as religious, this is quoting now the 2012 Obama administration rule, quote, "If the inculcation of religious values is the purpose of the organization, if it primarily employs persons who share the religious tenets of the organization, and if it serves primarily persons who share the religious tenets of the organization." This would effectively mean that only houses of worship or institutions that serve the direct expression or teaching of articles of faith could be granted religious liberty. Essentially, no religious charities could qualify, no hospitals or schools or adoption agencies, let alone private institutions that are run by religious people somehow in the service of their convictions. Religious practice in this understanding involves the profession of faith, but it doesn't extend to participation in the broader life of the society. It's essentially an intellectual exercise, and the freedom of religion is articulated in the service of the ends of the liberal society, rather than as a constraint on the reach of that society or on the power of that society over its members. Now, the case law that arises out of the Free Exercise Clause, of course, has long involved broadening these kinds of narrow definitions, and that's resulted in requirements for accommodations of all kinds for many different sorts of religious people in the public squares. But accommodations for religious institutions and communities have been more rare and more complicated. In this tradition, religion has rarely been treated as one of the things we really do together. And yet, there are in our tradition of religious liberty a set of arguments and categories that are much better suited to the kinds of challenges that religious people confront now. Arguments that see religious liberty as demanding some limitations on the reach and power of the liberal society itself, and that point in the direction of a communal understanding of religion that's absolutely essential to the practice, to the religious practice of both Jews and Catholics and many other Christians. James Madison, the author of the First Amendment, was actually among the original architects of these kinds of arguments, which are really distinctly American arguments and have to be understood, I think, as different or as at least alterations of what we think of as the tradition of religious tolerations. In his 1785 essay, Memorial and Remonstrance Against Religious Assessments, so this is written about 5 years before the First Amendment, Madison wrote this, quote, "It is the duty of every man to render to the Creator such homage and such only as he believes to be acceptable to him. This duty is precedent, both in order of time and in degree of obligation, to the claims of civil society," end quote. So religious liberty, in this view, is not quite a liberal liberty, at least as we're used to thinking about our rights and our freedoms. It's not a freedom to do what you want, it's a freedom to do what you must. It describes a duty of society to retreat and give its members space to act on what they believe is essential. It's an acknowledgement not simply of a human liberty or a right, it's an acknowledgement of a human obligation that precedes the social obligation and so shapes it. Madison also understood that at the core of this kind of religious liberty is the freedom not to be coerced into doing what your religion prohibits you from doing. He proposed that the liberal society should make room for a moral code that comes with constraints. In fact, Madison seems to suggest that a society that refuses to allow its citizens to be constrained by their religious convictions is an unacceptably coercive society. Its very liberalism can become oppressive. But Madison advanced this case not in the service of a protection of the free exercise of religion, but rather in opposition to the establishment of religion. His point was that no one ought to be compelled to affirm as true a religious tenet that he took to be false, that no one should be compelled to participate in a religious practice that violated his own understanding of his religious obligations. He was making what we now would recognize as a non-establishment argument that was not exactly an extension of the traditional Anglo-American case for toleration. But it's also the essence of the argument that, say, a wedding vendor who wants to remain free to refrain from participating in a same-sex wedding might advance. The question of the definition of marriage, for many people, of course, is a fundamentally religious question. It's also, in our society, a civil question. But some religiously orthodox wedding vendors are finding themselves effectively compelled by the civil authority to affirm an answer to that question that violates their religious convictions. And some religious institutions, from universities to social service agencies to private companies owned by Orthodox believers, are finding themselves forced to take part in the enactment and enforcement of a moral code that they are obliged to reject. They would like to be relieved of that compulsion, and they're being told they can't be because the larger society's understanding of the moral life should overrule the understanding that's prescribed by their religion. If they want to participate as business owners or as service providers in the life of that society, they have to give ground. And so in this respect, they're more like religious believers under compulsion in a society with an established church than they are like believers, simply denied the freedom to exercise their religion. But now the compulsive state religion, or at least our new kind of civil religion, is supposed to be a sort of progressive liberalism. Now, of course, liberalism is not literally becoming a religion, but it's approaching the question of society's moral order from the point of view of a dominant established power that expects to command a formal assent to its own views in the public square. People are allowed to believe whatever they want, but when they act together in public, they're expected to abide by the beliefs of the established order. That liberalism is not actually a religion means that the Establishment Clause will not avail us as a legal tool in the courts. Arguments in court have to continue to make the most of the Free Exercise Clause, which offers us some very vital protections. But that Madison's argument against religious establishment nonetheless does speak so powerfully to our situation can help today's religious traditionalists understand that situation better. For one thing, it brings into sharper relief the distinction between individual and communal religious liberty. In calling for keeping our national life free of the overbearing power of one church, Madison was not suggesting that instead we should have zero, but rather that we should have many. And by withholding public sanction from any one set of religious institution, his approach makes it possible for many religious institutions, not just religious individuals, to populate our public life. As a practical matter these days, religious liberty is essential, not so much because it protects people's ability to believe and say things, but because it protects people's ability to live in a certain way. That way of living, shaped by memory, bounded by tradition, directed to the future, formed to meet obligations, both sacred and profane, and of course ultimately answerable to fundamental truths, cannot be embodied in the practice of lone individuals, because at its essence it is about relational commitments. It describes a culture, and so it can only be given concrete form in a community. And it is a way of living threatened by the dominant culture of our larger society, a progressive culture that implicitly, and even if in generally well-intentioned ways, is coming to understand itself as a kind of dominant religion. The problems that this has posed have so far largely been problems for Christians, and maybe especially for Catholics. But because they are challenges to an ideal of religious liberty that understands religious life in communal terms, they're challenges that Jews have to be very alert to as well, and have to take seriously as challenges to our own freedom and our own thriving and our own way of life. The question of whether a religious school can operate in accordance with the demands of its religion, of whether a religious businessman can run his business according to the way of life of his community, cannot help but become very relevant to American Jews. And even while there's still predominantly threats to Christians, these are challenges we already should be taking very seriously. We have to take threats to the ways of life of our neighbors seriously, just as we should hope that they might take threats to our way of life seriously. And we should also take these concerns seriously because we ought to see that Jews in America owe our extraordinary freedom and safety to a distinctly American tradition of religious liberty, which combines the English tradition of toleration with a much deeper and broader American idea of society itself, a communitarian ideal that understands social life from the bottom up, from the community upward, and that is an ideal that we have to defend and uphold as Jews and as Americans. I think seeing these connections, clarifying them, articulating them, is part of the promise of what Tikva is doing here and what this conference is trying to achieve. So again, I'm very grateful to see it happening. I'm very grateful to be part of it, and very eager to see what folks think.
So right about now, your lunch is setting in, and the coffee and tea you had during the break is running out. And I guess my job is to try to keep you awake for Ambassador Dermer. I'll do the best I can. This is really extraordinary to see this room packed with so many of you, and I'm sure the other room as well, for this first conference of the Jewish Leadership Conference. It's a real testament to the Tikva Fund and everyone who organized this, and I hope this will be a tradition, because I think it's very important for the public policy community. I'm going to start from and let me say one other thing. Yuval, it's a privilege to be on this panel with you as well. Movements like the one we're seeing in Washington with the judiciary is an amalgam of a lot of different things. And what Yuval has done and what the Ethics and Public Policy Center has done is also very, very extraordinary in our public life in Washington and nationally. So I'm going to start from a somewhat different perch. Yuval talked a lot about the First Amendment, the Free Exercise Clause, and importantly, the Establishment Clause as well. I'm going to start with the structural Constitution, by which I mean those structural protections in our Constitution which limit the power of government and which disperse it. So the separation of powers, Articles 1, 2, and 3, checks and balances, federalism, bicameralism, those are a number of the essential features of what I call the structural Constitution. And the proposition I want to start with is the idea that the most important means of protecting religious liberty is to ensure the enforcement of and respect for that structural Constitution. Justice Scalia, before he passed away, used to say that any tin-eared dictator, any president for life, even the old evil empire of the Soviet Union, they all had lots of rights guaranteed by various charters. In fact, most dictatorships in our world have charters of rights and freedom that are multiples longer than the United States'. And most of the worst totalitarian regimes that deprive people of religious liberty have signed on to any number of different UN instruments, treaty instruments that guarantee freedom of religion, as well as a long list of other political and civil rights. But what those governments lack, and what ultimately protects freedom of religion, is structural limits on government power. Because any guarantee of religious liberty is, as the framers would have thought of it, a mere parchment barrier if you do not have a structural constitution that ultimately divides and limits government power the way we do, separation of powers, checks and balances, and the like. That was a bit of my experience when I served on the U.S. Commission on International Religious Freedom. I must have gone to close to 48 countries around the world, and what I noticed was most of those countries actually purported to guarantee freedom of religion or religious liberty. They would show us their statutes, they would show us their charters of rights, they would remind us that they had signed on to any number of different UN declarations that guaranteed religious liberty. But when you walked around in the streets, you didn't see it. You saw oppression by the state, either explicit or actual provisions that discriminated against people on the basis of religion, or a growing trend when I was on the commission, the problem of impunity, situations where private actors would deprive people of religious freedom or persecute people for their religion, and the state would just stand by and do absolutely nothing. It wasn't a problem of not having a guaranteed right written down somewhere. It was a problem that you had a lawless government with no structural protections for the people. So it seems to me that's the first thing you have to deal with if you really care about the freedom of religion. And we see it in many of the big cases that arise in our current day here in the United States. Let's take the case of the Little Sisters of the Poor and any number of other couple of dozen cases that involved the HHS contraception mandate in relation to Obamacare. Now, sure, the problem was you had a regulation that basically offended the conscience rights of the Little Sisters and a number of religiously affiliated colleges and so forth, who didn't want to provide health care that provided various kinds of contraception that violated their religious conscience. But at the core of the problem there was what? The idea that Obamacare as a whole was violative of our nation's separation of powers. At the end of the day, Congress had no power to do what it did. It violated the Commerce Clause. It violated the limited enumerated powers under Article 1, Section 8 of the Constitution. And if, as a first matter, our country had respected the separation of powers and the concept of limited enumerated powers, Little Sisters of the Poor and all of those colleges would have had no problem. Or what about the Indian tribe out west who used to use eagle feathers, what we call fallen eagle feathers that had dropped from an eagle? They didn't have to kill the eagle, they were just found on the ground, and they would use those feathers for their religious ceremonies. Now, we had to have an argument about whether or not that religious practice was protected by the Religious Freedom Restoration Act and by the First Amendment, but you know what? We didn't have to go further than the concept of the separation of powers, because the framers would have recoiled at the idea of having an Interior Department or a Bureau of Fish and Wildlife that had the kind of interim power that this particular agency had in dealing with that Indian tribe. You should look at the facts of that case. It was appalling, the kind of power that agency had, and that was because Congress delegated to an agency of the federal government undefined, boundless authority. And I would say that that case would not have happened had Congress understood and followed through with the kinds of separation of powers dictates that our Constitution provides. And then, I think of particular relevance to Jews is a dispute that has occurred with the Washington Area Metropolitan Airports Authority, where there was a Jewish employee who wanted to basically, I think, take Saturdays off, and the Airports Authority fired that person. And what were the arguments at issue in the case? You know, whether they had authority to do that, again, invoking RFRA and so forth. But again, the problem with that Airports Authority, it's extra-constitutional. It's unaccountable because it doesn't fall within the normal separation of powers, and the executive branch has no power over it directly, and nor does the legislative branch. I would say that if they did, this is probably a matter that it could easily have been resolved through the political process. But they were immune from the normal channels of political accountability. So before we even begin to talk about the First Amendment, which of course is extraordinarily important, there is a reason why it's the First Amendment, the first freedom in our country. Before we even begin to talk about that, if you want to protect freedom of religion, you better hold on to your structural constitution, because without it, the First Amendment will mean nothing. Now, when it comes to the judiciary and religious liberty, I think personnel is policy. And so again, if you get to the issue of the structural constitution and to the proper interpretation of the First Amendment, one of the most important things in my mind is the composition of the federal courts. And that's why I've spent a decent part of my life dealing with that. We've seen a number of successes over the past few years in this regard, and I'm going to just concentrate on three of them for a moment. And you may be familiar with these cases. One is Hosanna Tabor Evangelical Lutheran Church versus EEOC. And there, the plaintiff was a minister at a religious school who taught religion and led worship services. And she was fired for insubordination, and she sued. Now, the Equal Employment Opportunity Commission argued that there should be no ministerial exception in disputes between churches and their ministers, which meant that rabbis and priests and pastors should be able to sue over qualifications or fitness for their ministry. The Supreme Court ruled unanimously, 9-0. And by the way, the Obama administration was on the opposite side of this. The Supreme Court ruled unanimously that religious groups are constitutionally protected from government interference in the selection of their leaders, which is a very important decision. The second case, which got a lot more attention, which I'll mention, is Burwell versus Hobby Lobby. And most of you in this room probably know the Hobby Lobby case involving the conscience issues that I just mentioned in connection with the contraception mandate. There, the issue was the Obama administration's HHS mandate, which required the owners of Hobby Lobby, and by extension their owners, the Greens, to either pay millions of dollars in penalties or to provide insurance coverage for drugs and devices that violated the Greens' religious convictions. And the Supreme Court ruled 5-4 that the HHS mandate violated the Religious Freedom Restoration Act as applied to closely held corporations. Again, a very important milestone regarding conscience rights protections. And then most recently, you had a case called Trinity Lutheran Church versus Comer. And there is a group called the Trinity Lutheran Church Learning Center. It was a Christian preschool, and it applied for a state grant program that would pay for a safer playground surface made of recycled shredded tires. Their application ranked among the highest of those that applied, but the state denied the grant on the basis that the school was associated with a church. And the state of Missouri's Blaine Amendment, and many states have these amendments, prohibits religious groups from receiving public funds in any form. The Supreme Court ruled 7-2 that the exclusion of Trinity Lutheran from a public benefit for which it is otherwise qualified solely because it is a church is odious to our Constitution and cannot stand. So those are important advances on the issue of freedom of religion in our country. And I do think in certain important ways they have moved the dial. But there are clouds on the horizon and people need to be aware of them. First of all, with regard to discrimination of religion qua religion, that issue really has been left open in a lot of important ways. First of all, as I mentioned, many states have Blaine amendments, which is what was at issue in that Trinity Lutheran case, which permit discrimination against religious organizations solely because they're religious organizations. And importantly, in footnote 3 of the Trinity Lutheran case, Chief Justice Roberts seems to attempt to limit the holding of that case to the specific facts of the case, which do not involve religious content. And this is, for example, a cloud on the horizon because I think it raises real questions about what would happen with regard to issues like school vouchers, the topic that I think might be talked about on the other panel. So he says, this case involves express discrimination based on religious identity with respect to playground resurfacing. We do not address religious uses of funding or other forms of discrimination. So there's still a very open question about what kinds of discrimination could occur against religions. You also have what I call free speech, religious freedom hybrid cases, situations where a religious group wants to simply express its views or present content. It sounds a lot like just a regular free speech First Amendment case. We've seen 2 of those recently. There's a big dispute in Washington, D.C. right now regarding the Washington Metropolitan Area Transit Authority because the Catholic Church there, the Archdiocese of Washington, wanted to put some advertising out on Christmas and put those in buses and on metro trains around town. And WMATA has denied them the ability to present that form of advertising, though all other forms of advertising seem to be permitted. And then there are several states, including California, that have required religiously affiliated pregnancy centers to disclose where people could get abortions if they wanted them. Now you can imagine how that would create a really serious problem for some of those pregnancy centers or clinics. So we have some of these hybrid cases which are coming up, and it's not clear how all of those are going to end up. And then we have the variety of just conscience rights cases. Yuval mentioned one of them, which is the Masterpiece Cakes case, which involves the baker who didn't want to bake a cake for a same-sex wedding service. But you've got lots of other cases like this that could come down the road. Landlord-tenant disputes about whether a landlord has to rent his property to a same-sex couple. You have situations involving religious institutions, for example, adoption services that are run by religious institutions. There are a number that are run by Catholics and by Baptists in a number of states, where there's an interesting question as to whether a state or locality can require licensure to do those kinds of adoptions to be based on whether they provide adoption services for same-sex couples. So these are very much unsettled issues. which is where I want to end, which is to say, courts matter. These cases and so many others are basically going to pivot based on the character and quality of who serves on the federal bench. And we've been, I think, in recent years, fortunate that we've had a Supreme Court that has seen some of these cases the right way, but some of the thorniest ones are headed in our direction. And we need judges who are, one, going to respect the structural Constitution and understand that first and foremost, it is the power of the judiciary to enforce structural limits on government power in a way that makes sure we don't run into religious freedom incursions in the first place. Secondly, we need courts that are going to interpret the First Amendment establishment and free exercise clauses consistent with their clear text and original meaning. Most of these cases would be resolved favorably, providing a proper accommodation for religion under the original meaning and textual understanding of the Constitution. And thirdly, we need to understand that we've been a country founded on the idea that freedom of speech and freedom of expression matter. Religion is really no different. Religious expression is no different. It's another form of the expression of one's conscience. Madison recognized that in his essay on property, where he talked about freedom of conscience and freedom of speech and rights of private property ownership, all in the same context, all as expressions of our dignity and worth as people. And so we are going to need a bench of judges, both at the Supreme Court level and at the lower courts, who understand those core principles. And I think if we can achieve that over the course of the next several years, and I think there's a good chance of it because we're probably going to see over 200 vacancies over the course of the next several years, then I think religion might well be on a much firmer footing here in the United States, and we can still be a beacon for that kind of freedom for the rest of the world. So thank you very much for your time. It's great to be here.
So, Doreen, we'll start with you.
So I'm going to go into that other area that we're not talking about to ask how our work in trying to protect religious freedom is affected by a real serious concern that freedom of religion should not mean that religious law trumps American law. And I'm from Michigan. So in Michigan, we're not able to pass an American law for American courts bill because we have a very strong lobby against it, although we're working in little steps. And I really want to know what your thought is about this area where we're saying the laws of the religion, obviously I'm talking about Islam, that take away women's rights primarily, should not be favored over American laws that protect those rights. Do you have a comment on that?
Sure. I don't think that there's any problem with the enactment of provisions in Michigan or elsewhere that make clear that other forms of law, religious, foreign, or otherwise, do not trump American law. You know,
It does happen in Dearborn. The freedom of speech in Dearborn is shut down.
Yeah, I mean, the problem you're discussing is something which Europe has had to deal with over the past decade. Basically, they've gotten themselves into two difficult spots, right? One is they have been extraordinarily permissive in terms of the creation of various alternative juridical tribunals, and given those juridical tribunals, I think much more jurisdiction than is probably warranted. And secondly, because of where Europe is on freedom of speech issues, they've fallen prey to the idea that somehow or another, freedom of speech stops where so-called Islamophobia begins, whatever that means. I have real concerns about both of those trends. Now, I know that this is and Yuval, you may know more about this than I do, but I know these are both thorny issues for the Jewish community, right? Because obviously in Europe, one of the things that has propelled prohibitions on hate speech is, of course, the horror of what happened in Europe and in Germany in particular. And of course, I am not, by any stretch, an expert on this, but I know that in some communities around the United States, there are, I guess, various Jewish tribunals which need some flexibility and some space to do what they do for their communities. My sense is that there are distinctions that can pretty readily be made between what the Jewish community might be concerned about in both those contexts and what's going on with Islamic Sharia courts and with hate speech. But that's not an area that I'm an expert on.
Well, I would just say, to stress something that Leonard said in the course of his comments, too, I think part of the problem they're facing in Europe is a lack of structure of a sort that we have in our constitutional system to begin with, so that the lack of a clearly formed structure for rights, for protecting rights, means that when you have a community pressing for its own rights, everything is done in an ad hoc way. It'll go as far as it'll go, and it becomes a purely political issue. Here in the United States, these can be constitutional questions, questions of the proper structure of our system of government, in ways that allow us at the same time both to be more protective of people's rights, but also to have clear lines of authority, and to have a much more structured and therefore clear understanding of what our legal system is and isn't. And so these kinds of disputes ought to be very different in the United States than they are in Europe. There are places, and I think a couple of states have become very confused about this, where it has not been taken up as a fundamental constitutional question, and instead it becomes the kind of political issue that gets taken up by political correctness. I think that courts should be able to draw distinctions that make these lines very clear by drawing on the precedents that are available to them in American constitutionalism. And drawing distinctions is part of what courts are for. We should aim to do that. These fights are necessary. The existence of the fight is not the problem. But I do think that the fact that we're seeing at the level of some states the amount of confusion that we're seeing is evidence of what Leonard suggests, which is that we've become forgetful of what our constitutional system is actually supposed to be and what it's supposed to look like.
Okay, we have a line.
You have a line forming.
We have a
in the back,
line
yeah.
forming with questions.
Yeah. If we would, we can come up on the line, ask a question, and then take your seat so we can kind of get the line moving, get the question answered. Thank you. Go ahead.
Will Scharf from Missouri. In my experience, Christian communities, evangelicals, Catholics, et cetera, seem to be keenly attuned to the risks to their faith communities that are out there in this space, whereas the Jewish community has been sort of slow to build awareness around the threats of a shechita ban or a ban on bris milah or things like that. What do you think is the driver of that awareness gap, if you agree with my assessment there, and how do you think we combat that?
Well, I could speak to it briefly, and Leonard may know more too, but I would say I think that there are a couple of factors at work here. There's a general unease with identifying with the concerns of religious Christians in the American Jewish community. I think that that unease should not be nearly as strong now as it still is. We talked about some of that in one of the sessions this morning too. I think, in fact, the interests of religious Christians and religious Jews are very much aligned these days. But, a lot of American Jews are not there. They're not comfortable saying their problems, the problems of evangelical Christians and Catholics, are our problems. And on the contrary, tend to see religious Christians as posing a threat. And so I think there's a kind of mental barrier there that makes it hard for us to understand that the challenges that some of our neighbors and fellow citizens are dealing with ought to be understood as our challenges too.
Obviously, I don't know the Jewish space anywhere near as well as Yuval does, but I can give you one sort of nuance on the Christian side of the equation. Catholics and evangelical Christians come at these problems from somewhat different vantage points and don't always have the same level of engagement on them. And part of that is different experiences they've had throughout U.S. history. So, Catholics have a history of being really concerned about certain aspects of religious accommodation by government, right? This goes back to the 1950s and 1960s when there were schools around the country that wanted to read verses from the King James Bible as part of class, and they were going to use various prayers that were more Protestant in their formulation than Catholic. And so the Catholic Church and Catholic leaders, sometimes imbued with that history, approach some of these religious freedom conflicts a little bit more slowly. But if anything has gotten them to step on the gas pedal, it's been the conscience mandate issue, from the past several years. And now I think evangelical Christians and Catholics are much more aligned on these questions than they used to be. But there are cultural differences between evangelical Christians, Catholics, and Jews, and I think that does to some extent affect the way in which we all think about how to approach these issues.
Jonathan Sack from Brooklyn. In the case of the baker and the same-sex couple, one of the strongest arguments one hears on the left is that is essentially like blacks at lunch counters during the civil rights era, and that in thinking about social coercion and economic freedom, we should err in terms of coercion in a situation like that. And I think it can be a particularly difficult issue for Jews who are at the forefront of the civil rights movement in trying to say that individual self-expression and dignity should overcome economic freedom in certain situations, economic rights. And I'd like to just get your thoughts on how you work through what I think can be a very challenging argument.
I really view the Masterpiece case, which is the case you're referring to, more as a case involving First Amendment expression than freedom of religion, frankly. There's obviously an overlap, and we've had other cases before the Supreme Court where that's the case, religious campus newspapers and things like that. But here's the situation. Basically, this baker was being compelled to participate ostensibly in a service that he didn't believe in, with knowledge of the situation and with a clear problem from a standpoint of conscience. There's not an analog between that and the lunch counter. The analog between the lunch counter and a baker would be a situation where a gay couple walks into a bakery and wants to buy a loaf of bread. Okay? Now putting aside whether there should be a law that prohibits a baker from, how he should sell his bread or whatever, that's the analog. Should a baker take all comers when they're going in to buy a loaf of bread, which anybody can buy? Or a birthday cake. Happy birthday, Tom. Well, there's nothing there that violates the baker's sensibilities or rights of conscience from a religious standpoint. Just like there wouldn't be if a gay couple walked into a diner and sat down at the lunch counter. So that's the analog, not the one that you were proposing. But I agree with you. That's the analog the left is trying to throw up. And I think what's incumbent upon all of us is to understand the facts and circumstances and to draw distinctions where they exist. So,
I agree with that, and I would point to maybe a slightly different way of drawing the distinction. I think we have to say that the resort to the analogy of civil rights is not ridiculous in the sense that the question of race in our country has been held up properly and correctly as an exception to a lot of defaults in our civic life, and legal culture. We have a default preference for freedom of association and for all manner of personal freedom of contract, and we make exceptions in the case of race. And I think it makes sense to say that living in a free society is not a matter of just applying principles in the abstract and following a formula. A society is a living organism over time. It lives with its own history. And in our history, the question of race is different from everything else, and it appropriately ought to be treated as different from everything else. It is an open wound that does not go away just because slavery is abolished or the civil rights movement has happened or various kinds of laws for access to the ballot have been passed. It is still a living wound in the life of our country, and it is appropriate that we ought to make exceptions to our default preferences and expectations around that subject. It is not appropriate to treat that as an analogy for everything else in American life. And we ought to be willing to say so, that our own history has to matter to us and has to shape how we live together. And so the fact that in America in particular, there is a history around race that demands that it be treated differently from other things ought to speak to this question. It ought to mean that we take the analogy seriously, not that we say that's absurd, but also that at the end of the day, we dismiss it because it is not analogous. Because precisely given the history of our country, of our society, given our history living together, and the failures to treat other human beings as human beings evident in that history around race, we have to take this kind of problem seriously. But when we treat everything else as analogous to civil rights, then we treat civil rights as no longer special, as no longer distinct, as no longer requiring a kind of treatment that arises out of its place in American life. And I think that would be a failure to live seriously with our own history.
Yeah, Robert Blum, White Plains, New York. And first of all, it's a fantastic panel. Thank you very much. Mr. Leo, your organization, I was involved back in 1984 at University of Chicago Law School. It's come a long way, so congratulations. Question, and I hope I don't stump you on this one. This is for Mr. Leo, I think. The playground case. If you don't read every Supreme Court opinion, you kind of don't have a sense of just how far left the left wing of the court is. So could you explain to me, you said it was a 7-2 decision. What was the argument of the two in the dissent? No, I mean, I'm not trying to be disrespectful of this, but I'm just trying to understand, like, what were they arguing and dissenting?
My recollection is that basically those two dissenters buy into the underlying rationale of the well, there's the stated rationale of the Blaine amendments, and then there's the real rationale. Okay, the stated rationale was, look, we can't be giving money to religious institutions, even if what they're asking for is something that's generally applicable, that another groups are asking for as well. Once we start giving money to religious institutions, the entanglement, right? This is what they hang it on. It's an entanglement question, right? Gosh, if we start giving money and we start looking at their grant applications, or we start granting them dispensations, we start making them a part of what we do for other institutions, we're going to entangle ourselves with religion, and we're going to get into the business of engaging in all this sort of detailed specking of what religions are doing, what they're not doing, and so on and so forth. That's the stated rationale. As Yuval said, courts are in the business of making distinctions, okay, and so are public policy leaders. I've always found the entanglement argument to be quite specious. You want to see entanglement, go back to the medieval period, okay? That's entanglement with religion, okay, where, the crown or the monarch is really subservient to a religious institution, okay? But, of course, we know that that's just the pretextual stated rationale for Blaine Amendment type arguments. The real argument is that there's a hostility toward religion, and that they'd rather see religious institutions wiped away from the playing field. I don't know that that's necessarily the motives of those two justices, but certainly the problem with their argument is that in practical effect it leads to that. In the Trinity Lutheran case, I believe it was, I know it was Justice Sotomayor, and I don't remember who the second one was. Was it Ginsburg? Okay, all right. That makes sense. Although she came out the right way on Hosanna Tabor. But anyway.
Shelley Rubenfeld Houston. My question's related, not about legal reasoning, but thought underlying decisions. And the one in particular is Roe versus Wade. Being a physician, I was surprised to read about the rationale for dismissing the Hippocratic Oath, which is that it, in essence, did not persuade Greeks and Romans to abandon abortion practices. But specifically, as it relates to religion, a very short paragraph which ended with this statement: ancient religions did not bar abortion, which seems like a spacious statement on its face. How does that reasoning figure into legal judgment when it's not a legal statement, ancient religion does not bar abortion, but yet it was a justification for their decision?
Well, I think Roe v. Wade is probably a bad model to use for what decisions should look like.
Okay.
Thank you. Really, I think even people who agree with where it ended up think that it's just a terrible example of a judicial decision. And so I'm not a lawyer. Apparently there weren't enough Jewish lawyers, so Tikva couldn't find one to put on a panel. But so they picked a political scientist.
I'm a lawyer.
But yeah, exactly. So we have one. I would only say that I think that your sense that the decision is a model of poor reasoning certainly seems right to me.
Is there another judicial opinion where those same people have cited what religions do? Gee, I don't think so.
I see.
Not to mention the fact that those same justices, whichever ones are remaining, didn't seem to mention that there are less than 8 countries in the world that actually allow same-sex marriage. So apparently, trends in religion and culture don't matter to them in any other context. And so I think that you can pretty much say that that line in the Roe v. Wade case probably was.
So this line, any line of reasoning like that is not subject to legal review.
It's not a line of reasoning at all.
Hi, I just wanted to ask that despite the current improvement in the federal court system and the Supreme Court specifically, given that in Europe in the last year, 60 homes in Germany alone were raided for quote-unquote Islamophobic Facebook posts, and there are actually hate speech laws in the United States, do you believe that 15 years from now it is an inevitability that we will lose our right to free speech as we know it, and encompassed within that our right to free religious expression?
Well, I don't think it's an inevitability, but I think that avoiding it will require taking seriously the case that Leonard made in his talk, which is not just about remaining faithful to the First Amendment, but to the structure of our government more generally, and to the idea that there ought to be limits on the reach of government power into private life and into civic life.
This is up to your generation. This is up to your generation. I am deeply concerned about this situation in our culture. Number one, we are a minority in the world right now. When I served on the UN Council of Human Rights and the UN Commission on Human Rights in Geneva, and when I served on the U.S. Commission on International Religious Freedom, this country was swimming upstream on the matter of what forms of speech ought to be prohibited. And during the Obama administration, we actually conceded a number of critical points in that regard, which are going to have to be reasserted during the present administration in Geneva and at the UN. So number one, the hate speech, Islamophobia bandwagon is filling up, and the U.S. is becoming a minority. Secondly, the polling data on respect for freedom of expression and freedom of speech is really concerning. Take a look at some of the polls that have been out there. Millennials do not care about free speech the way most people in this room do. They don't view freedom of speech as precious a commodity as we do. I can assure you from the polling data. that is something you should be very, very seriously concerned about. And I don't know how you put the censorship genie back in the bottle, but the trend is very disturbing, very disturbing.
Hey, Ken Gartner from Merrick. Dr. Levin, as I understood it from your talk, you were talking about the issue of freedom of religion as becoming one involving the establishment of religion to the extent that progressive ideology seeks to encompass the public space and require people to limit what they otherwise would, or to compel them to perform certain things that are anathema to their own personal belief. Now, I recall reading your thoughts on this initially in a blog post around the time of the Indiana bakery case under the heading The Church of the Left. And as a matter of fact, Dennis Prager during lunch today spoke of the issue in much the same terms. Yet I seem to hear you come to the conclusion today that, well, because leftism isn't really a religion, it's not really fruitful to approach it from that point. And I was wondering, am I mistaking your analysis, or is your conclusion based on the jurisprudence of this area with which I'm really not familiar? I was just wondering if you could clarify that. I'd appreciate it.
Yeah, well, thank you. I would say the difference is a distinction between the legal argument around it and the broader political argument around it. As a legal matter, I don't think the Establishment Clause is the way to go at these challenges, because you don't have a state imposition of religion here in any formal sense. But I do think that to understand the nature of the challenge that a lot of religious communities face now in America, you do need to see that to a significant extent and in some very interesting ways, the behavior of the cultural left is the behavior of an established religion. It's an expectation that life in the public square should be governed by the moral principles of a kind of church of progressivism. It's an analogy. I'm not suggesting that that's literally what's happening, but I think it's an analogy that helps us understand the challenge we face, because if we only think of it in terms of the exercise of religion, then I think you miss a crucial element of the problem that religious people face in the public square, which is that they're being compelled to participate in a moral order that they believe violates their understanding of moral order. And so I think the baker being forced to essentially participate in a same-sex wedding is more like the Jew in 18th century Britain being forced to be baptized before he can run for parliament, than someone being told that they can't open a kosher deli. These are all important kinds of questions that might arise around the intersection of religion and life in a free society. But I think the analogy can help us understand why this is such a challenging problem, because ultimately we're being told in effect that we have to accept certain things as the price of admission into the public arena. And that is so foreign to the way that American life has thought about religion that it has to be understood by an analogy to a much more extreme situation that I think is unlike what we ought to abide in the United States.
Hi, my name is Alan Shiner. I'm from Manhattan. And my question for you has to do again with the civil rights movement and segregation. And I think one principle that has created a lot of difficulties for religious people in the courts recently, because it came out of that line of cases against segregation that tradition is not a reason that you can expound for your legislation, right? It's not a value that the courts can consider that something is traditional. And because tradition was expounded as a reason for segregation, even though there was not a very long tradition of it, that was claimed. And so today, ideas like, for example, modesty, which comes up in the bathroom cases, where the rules against having sex-exclusive bathrooms, gender segregation in the bathrooms have been challenged by people saying, well, we just, as a matter of modesty, don't want to share bathrooms with the opposite sex. The courts say, well, that doesn't count. It just simply doesn't weigh in the balance. because that type of idea can't be articulated in a utilitarian way. And I think that, and you see this in the same-sex marriage area, that if you can't articulate an idea in a utilitarian way, then about, basically public health or somebody's physical well-being, then you just lose, because philosophically, arguments about taboo and sacredness are just not accepted. Is there a solution to that? Are there arguments where those types of values can get traction in the courts?
As a lawyer, I look for a real firm foundation to base some of these constitutional arguments. And when you look back at the history of civil rights and race, we're dealing with a very, as Yuval said, a very unique set of circumstances and facts in American history. I mean, there's a reason why the Supreme Court talked about invidious discrimination in the context of race. It was this very clear, visible, and immutable characteristic. There was absolutely no alternative rational justification for the forms of discrimination that was taking place. When you get into the context of distinctions and discrimination in other contexts, for example, in the context of the bathrooms issue that you mentioned, there are lots of first of all, you don't get into the same debate about immutable characteristics and readily discernible discrimination in the same way you do with race. And secondly, there are all sorts of public policy arguments that you can make regarding safety and so forth that justify the enactment of sex-separated bathrooms. But finally, the final point I would make here is, civilizations have been making distinctions based on tradition and culture for centuries. Some of those distinctions are perfectly appropriate because they're grounded in the natural order of things. Okay, some of them are debased and profane and do not recognize the dignity of the human person. Okay, I would argue that in the distinction you're trying to set up, prohibiting discrimination on the basis of race recognizes the dignity of the human person. Having sex-separated bathrooms, recognizes the dignity of the human person too. And there's nothing wrong with our legal system and our public policy system making those kinds of distinctions and understanding what is rooted in the natural order of things. Race discrimination was not and ever will be rooted in the natural order of things because it makes no sense from any standpoint, anthropological, sociological, scientific. So anyway, I think that the left has become intellectually sloppy and flabby. They're not capable of making distinctions. They make ad hominem arguments. They are not grounded in the craft of the law the way they used to be during the civil rights era. And as a consequence, they are incapable of making the distinctions that are the hallmark of a legitimate, just Anglo-American justice system.
Okay. For all additional questions, I'm going to ask that you wait until after we break. Our speakers are sticking around. I just want to make sure that everybody gets out on time and gets to use their full break. So let me thank our speakers for their wonderful presentations.